My name is John Burke,
And I'm Tanya Kemp.
and this is our presentation on arbitration. Arbitration. What is it and why is it important? Arbitration is a form of alternative dispute resolution where the parties, through contract, submit their dispute to an impartial tribunal for resolution by one or more arbitrators. Arbitration is usually binding, used in both the private and public sectors, and is usually paid for by the parties. The most frequently used private agency for arbitration is the American Arbitration Association. Arbitration helps to ease the court backlog and can provide a quicker and less expensive forum for the parties. Arbitration works towards some of the values of the judicial system, namely efficiency and affordability.
Overall arbitration process. Under AAA rules, arbitration of all types are started with a demand for arbitration. The party filing the demand is the claimant and the party responding to the demand is the respondent. The demand for arbitration has to be served to all opposing parties. The case administrator will send out a list of potential arbitrators to the parties as well as a request for available hearing dates. The case administrator is usually a staff member from the AA assigned to the case. An arbitrator is agreed on by both parties and is usually an expert in the dispute issue. The arbitrator will make a binding decision rendered as the arbitration award at the conclusion of the arbitration hearing.
Preparation for arbitration. Preparation for arbitration consists of the following steps: gathering all documentation and papers that support each side's positions, subpoenaing any documents from other parties that are needed for arbitration, determining who will be called as witnesses at the arbitration hearing, preparing for direct and cross-examination of each of the witnesses, and preparing a final written arbitration brief.
Arbitration hearing. The hearing will be held within a few months of filing the demand for arbitration. The case administrator will set a date for the arbitration hearing based on the dates received from the parties and the availability of the arbitrator. Arbitration is unlike a trial in the following ways. A court reporter is not present at the arbitration to make a written transcript of the proceedings unless requested by parties. Hearing is much less formal than a trial, usually taking place in an office at the AAA. After both sides have presented their case, the arbitrator will declare the hearing to be closed. The arbitrator has 30 days in which to render the arbitration award. The prevailing party may then petition need.
Cons of arbitration. Although arbitration is very popular, there are some cons associated with the process. For example, once an individual signs a contract with an arbitration clause, the individual must proceed with the arbitration process. This is beneficial for companies in order to avoid publicity because the process of arbitration is private. However, it may be harmful to an individual who wants to file a claim in court. In addition, there is no jury at arbitration. Having a jury is an important right that most individuals do not want to relinquish. An arbitrator considers all evidence and makes the final decision in the place of a jury.